Thank you very much for inviting me to this conference. I'm very thankful to Professor Riemer and Professor Abbas, and also I'd like to indicate my appreciation for the excellent work they have done, and in particular to Professor Abbas for the contribution he has made to the publication of the South Center, an intergovernmental organization of developing countries in relation to intellectual property, access to medicines during the COVID-19. Thank you very much, Professor Abbas, for that. I was requested to make a presentation about the so-called TRIPS waiver. This is the decision taken by the 12th Ministerial Conference of the World Trade Organization on the basis of requests made by India and South Africa. I will make first a reference to the context in which this decision was proposed and then adopted, and I will make reference to some of the negotiating positions, and I will make some observations about the interpretation of the decision. That's about the context. I think we are very well aware that during COVID-19 there was a shortage of supply of vaccines, and the main reason for this was the lack of access to technologies in order to rapidly expand the manufacturing capacity. Paradoxically, while some developing countries were not able to get sufficient vaccines to prevent the disease in their populations, some developed countries were able to purchase vaccines in excess of their need. In some cases, developed countries purchased 4 or 5 times what their actual needs were. And then the crucial issue was not so much manufacturing capacity as such. In fact, in many parts of the world, including in many developing countries, there was the capacity to produce vaccines. For instance, some plants, some facilities can be repurposed in order to produce vaccines while they were producing biologicals. So this is not very difficult. This can be done. But the main problem was rapid access to technologies. And as you may also be aware, there was a reluctance by the companies that produce COVID-19 vaccines to share the technologies. For instance, the World Health Organization established a pool. The acronym for that is CTAP. That was initiated by the President of Costa Rica in order to encourage companies to share technologies of this type. But this never happened. In particular, the 2 companies that produced and distributed messenger RNA technology vaccines, they refused bluntly to share the technologies. And therefore, a clear obstacle to expand manufacturing capacity was access to technologies, and there intellectual property plays a role. And this was the perception by developing countries. And this is why India and South Africa, with a co-sponsorship of a large number of developing countries that support many other countries, made a request to get a waiver for the obligations in the TRIPS agreement related to patents, to undisclosed information. This means especially know-how, which is very important in the production of vaccines, also in relation to copyrights and designs, in order to facilitate access to these technologies and rapidly expand the capacity to produce vaccines, and then solve the problem that many countries were facing. So this was the very purpose of this request that did not get a very enthusiastic response on the side of developed countries, that in many respects they just reflected the interests of the big pharmaceutical companies that wanted to preserve the monopoly or the secrecy of the technology to produce vaccines. And therefore, almost 20-month negotiations took place whether this waiver should be granted or not, or under which conditions. The position of the European Union was of particular interest because before these negotiations took place, the European Commission opposed the grant of compulsory license. For instance, in the case of Thailand, they granted 7 compulsory licenses on the argument that this will not provide incentives for innovation, that will weaken the intellectual property system, so on and so forth. But during the COVID-19 negotiations of the waiver, the European Commission took a different view. They said, why should we negotiate a waiver if we have the compulsory license? So they actually became major promoters of the use of compulsory licensing system And their argument was, we only need to just clarify some provisions in some aspects of Article 31, eventually Article 31bis, but that there is no need to waive the obligations under the TRIPS agreement. That was precisely the request done by the proponents that wanted several sections of the TRIPS agreement to be waived. The negotiations went on. The United States took the position that they were prepared to discuss about a waiver for vaccines only. They were able to engage in text-based negotiations, but of course, as I mentioned, the USTR, or the negotiators for the United States, very strongly represented the interests of the big pharmaceutical industry. They didn't want to share the technology in order to expand the manufacturing capacity. Then in the end, this decision was taken after long negotiation. During the conference itself, day and night, negotiations took place on the basis of a text that aimed at a very limited waiver, that is only one provision, Article 31F of the TRIPS agreement, an article which is very, very peculiar. It does provide a compulsory license can be granted in any member of the World Organization in order to predominantly supply the domestic market. So this means that compulsory license cannot be granted just for export. The rationale for this provision is very unclear. I have not seen any precedent, any literature, academic work justifying this limitation. It was most likely one provision that was suggested by the United States during the negotiation of the TRIPS agreement. It was accepted perhaps without further elaboration on the implications. But then interestingly, as you may also know, there was a need earlier to get a waiver on this particular provision during the HIV/AIDS epidemic, because it was found that there was a need to grant compulsory license for export of medicines to address this disease and other diseases. And this limitation was an obstacle. And then based on paragraph 6 of the Doha Declaration on TRIPS and public health, then a waiver was adopted also after very long negotiations in the year 2003, again on Article 31 paragraph F. So the waiver that was adopted now at the 12th conference of WTO is on this particular paragraph. It also contains some clarifications which do not add anything to what we had before the decision was adopted. Now, just to make a brief analysis of some elements of the decision, the scope is limited to vaccines, while the proponents of the waiver actually wanted to address also other products, equipment, whatever was necessary to address the pandemic. But there was a strong resistance by developed countries, and in the end, the resistance led to a very limited scope. It's just about vaccines, COVID-19. There is one paragraph in the decision, paragraph 8, that indicates that further negotiation would take place in order to make a decision in 6 months about expanding this waiver to therapeutics and diagnostics. But right now, this expansion has not been approved, and there is quite clearly an opposition by developed countries to expand the scope of the decision to beyond vaccines. In terms of the subjective scope of the decision, this waiver does not apply to all members. It's only to developing countries, which are called eligible members. But there was a clear attempt by developed countries to exclude China from the possibility of using this waiver. And then there was wording that indicated that countries had provided more than 10% of vaccines would not be able to use the waiver if adopted. This wording was rejected by China, but finally made a commitment during one of the meetings of the General Council that they will not use the waiver if adopted. And then interestingly, one footnote in this decision includes a very strange provision for under WTO, in accordance to which statements made during the General Council meetings may become a commitment. And this was the way of excluding China from using the waiver, which is paradoxically in many respects, because if a country has the capacity, as it was shown by China, not only to produce for the local market, but also to export large quantities of vaccines. So the rationale was to allow such a country to use the waiver and not to exclude it. In any case, this was finally adopted. Another area of, it was very controversial, was what kind of technologies would be subject to the compulsory license system as way by this decision. And interestingly, there is one footnote in relation to paragraph 1, which is footnote 2, just 2 lines. It took hours for diplomats to negotiate these 2 lines, because the fear by developed countries was that the scope of the waiver would include not only ingredients and processes for the production of vaccines, but also eventually equipment, for instance, that may be needed in order to administer or to protect the health of the people. And therefore, it took hours to discuss this wording. In the end, the wording, I would say, opens the window, opens the door for a broad interpretation, because it says that inventions that may be subject to compulsory license under the decision includes ingredients and processes necessary for the manufacture of COVID-19. So the word includes means that this is not an exhaustive listing, and therefore there may be other components. For instance, it may be vials or equipment for the production of vaccines that may be covered by the waiver. In paragraph 2, there is a clarification saying that compulsory license can be granted under this waiver on the basis of any instrument, which is really not necessary to be clarified. This paragraph, however, contains a very strange element. It says that even countries without compulsory license systems can grant such a license under the waiver, which is very, very, very problematic how this can be done if at the national level this is not regulated. Anyway, in the third paragraph, which is the key paragraph in the decision, it is said in the first place that there will be no need to negotiate, to have prior negotiations to get before getting a compulsory license, as it is requested under Article 31 of the TRIPS agreement, except for under some circumstances. Again, this clarification was not needed because we are dealing with a situation of emergency. So this clarification is there, but in the end, it was not necessary. And then in the second paragraph B of this paragraph 3, then there is the actual waiver about export of vaccines to eligible countries. So this waiver can only be used as exporting countries by eligible members, means developing countries, except China. And exports can only take place in relation to eligible members, again, developing countries. But interestingly, or perhaps unfortunately, this decision does not deal with the situation of the importation of vaccines. It provides for a waiver for the export, but this does not provide for the waiver in case that the vaccines or some components of the vaccines, which may be the case, are subject to patent in the importing country. And therefore, if this situation arises, then there will be a need to grant a compulsory license in the importing country, which is not dealt with at all by this decision, unlike, as you may recall, the case of Article 31 bis that was incorporated in the TRIPS agreement. If a compulsory license is not available, you might think that the importation of these vaccines could be allowed under parallel importation. But the problem is that many laws in the world that do provide for parallel importation subject this to the fact that the products were put on the market in the exporting country by the right holder or with his consent. In this case, we have a situation where the product is put on the market by a compulsory licensee. That means without the consent of the right holder. And therefore, in many cases, part importation provisions will not be available to be used in order to allow for the importation of products which are produced under this waiver. So this decision also contains some requirements in order to prevent the re-exportation of the vaccines which are produced. So countries, eligible members which receive importation of vaccines, they are required to take all reasonable efforts to prevent re-exportation, which is also questionable because in a situation like a pandemic, what you want is to any country to get access to vaccine as soon as possible. So this restriction of exportation will be against, in the end, to the very purpose of the decision. And also contains some requirement of making available measures to prevent the importation in any member of vaccines which are produced in a manner which is inconsistent with the decision. So these two requirements means that some elements need to be at the national level in order to prevent exportation and also to give the right holder eventually the measures, to give access to measures that will allow the right holder to prevent importation. Whether it was necessary or not, in my view, this was not really the key issue to be addressed. And also there are some notification requirements which are not in Article 31 of the TRIPS agreement. So this waiver actually goes beyond Article 31 on compulsory license or other authorized use in the TRIPS agreement, because there is an obligation to notify the Council for TRIPS in the case a measure is taken to allow for exports under this waiver, and also there is an obligation to notify the name of the entity, the subject matter of the compulsory license, and the quantities to be supplied. But I think it's very important to make a good reading of this decision, because the reference to quantities, in my view, should not be interpreted as requiring that a compulsory license be granted with an indication of a limited quantity, as it is the case actually under Article 31bis. So these quantities may be just unlimited. The compulsory license could be granted in order to allow for the production and export of any quantity of vaccines. And this is very important because in the case of Article 31bis, this requirement of indicating the quantity is a major obstacle, because if a company gets a compulsory license to export under Article 31bis, it can only be done for a limited quantity. If more of the same medicine or vaccine is needed, then there is the need to get another compulsory license, which procedure is very complicated. So it's a burdensome provision in many respects. So it will be important, of course there is no time to go into further details on interpretation, but also it would be interesting to look at in paragraph 1 of this decision, there is a reference to the extent necessary to address the COVID-19 when this paragraph refers to the possibility of granting a compulsory license. But then it would be interesting to look at this wording, and some have given the interpretation this wording incorporates into the decision the so-called necessity test, which has been interpreted in a very narrow manner under WTO jurisprudence. In my view, however, this necessary to address the COVID-19 should not be read in connection with the grant of the compulsory license as such, but in relation to whether the subject matter of the patent is necessary for COVID-19. In a paper that a colleague of myself, Nirmala Sayan, and myself, we have written on the implementation of the decision, we make some elaboration about what should be the right interpretation of these paragraphs. So the decision has these complexities. Today has never been used. I think it has been late. It has been narrow in terms of scope, and therefore now, given the situation of COVID-19, it's very likely, in fact, that it will be used. But let me end by just mentioning that this was the route that was chosen by a number of developing countries to get a waiver of the TRIPS agreement. This means that the multilateral, an agreed mechanism in order to allow for waiving the provisions in the TRIPS agreement. As I mentioned, they failed to a great extent because the waiver has been adopted late and is very narrow. But I just wanted to mention that there were alternatives, and the South Starting, in fact, alerted about these alternatives very early when the COVID-19 pandemic started. And this is, in particular, Article 73B of the TRIPS agreement, the national security exception, that can be invoked by any member in an emergency like this, international emergency of this kind. But developing countries, they thought it was better to go through a multilateral way and not just to go unilaterally and use the national security. Perhaps in the future, given the experience with the COVID-19 and the very narrow waiver that was adopted, perhaps many members will opt to go directly for this unilateral solution, which is contained in Article 73B. And another exploration that could have been done during this situation relates to Article 30. In the reading of many scholars, and also this is my reading, Article 30 will allow for the production just for export of a product which is subject to patent protection or which is the outcome of a patented process. If you read Article 30 in the view of many, including myself, there is no limitation for granting compulsory license for production just for export. And the very reason for this is that if this occurs, in fact, the market in the country where the patent was granted will not be affected, because the product will not be sold in the market where the patent is granted. It will be sold in a foreign market. And even the possibility of exporting the product and the compulsory license will be limited in case there is a patent in the foreign market. So this could only happen when there is no patent, compulsory license, or foreign importations are eventually allowed. So therefore, there are strong reasons to support the idea that there will be a different approach to situations like this, or export of medicines in particular, in which Article 30 may be used. So I leave you with this comment, and I invite you to consider this in your deliberations, and thank you very much for your kind invitation.